Have you been arrested for a felony? Are you charged with a felony? That's a really important question, and I'm making this video because it often gets confused in Washington state. My name is Lance Fryrear, and I'm the owner of the law offices of Lance Fryrear. We're a criminal defense firm that have been defending people charged with crimes, including felonies, for more than 20 years. And in this video, I'm going to cover what is the difference between a felony and a misdemeanor. If you've been arrested for a felony, are you charged with a felony? And 3, what are the common mistakes to avoid that happen all the time if you get arrested for a felony? So if you find this video useful, please please wait till the end to subscribe, and I'm going to jump right into it. Number 1, what is a felony? What's the difference between a felony and a misdemeanor? Well, a felony is basically a more serious crime. The legal definition in Washington state basically means anything that is punishable by more than 1 year in jail, more than 1 year. So there's Class C felonies, 5 years in jail max, Class B felonies, 10 years in jail max, and Class A felonies could be up to life in prison. So non-felonies are called gross misdemeanors and misdemeanors. A gross misdemeanor means 364 days in jail maximum. A misdemeanor, 90 days in jail maximum. Think about a gross misdemeanor as a DUI or an assault in the 4th degree. Think about a simple misdemeanor as resisting arrest. Think about felonies as an assault that's got a broken bone or stitches or a weapon, or a sex offense like rape or things like that can be felonies, or really large property crimes. Crimes with guns are often felonies. And so felonies are very serious. If you're convicted of a felony, you lose your right to vote. You lose your right to possess a firearm. In most cases, that's not true for non-felony charges. So, number 2, if you're arrested for a felony, does that mean you're charged with a crime already? Well, and almost always the answer is no. That law enforcement officers have the power to arrest people for investigation of felonies, but they don't have the power to sign their own criminal complaint and charge somebody with a felony. And that's a big difference. Okay. So for non-felony charges, city police officers can arrest someone for like a gross misdemeanor DUI and write their own charging document and file it into court, and the defendant is charged. For felonies, a police officer can arrest you. They can write what's called a probable cause statement justifying the arrest. And now the court has to process it in a certain way, where there's only basically 3 court days you can be held without the prosecutor filing a formal criminal complaint. And so it's important to realize just because you're arrested for a felony doesn't mean you're charged with a crime yet. So it's not time to give up on the case. Big time. People make those mistakes all the time and make the wrong assumptions. So that's number 3. What are the pitfalls? What do you need to worry about? The main thing if you're charged, take that back, arrested for a felony. Most important thing to realize is that it is not over yet. What usually happens is a suspect is arrested for investigation of a felony. Let's say it's theft in the 1st degree. You get accused of taking some property and you get arrested and you go to court. And the court rules say that the court has a certain period of time to set a bail on you, where you have to pay money to get out of jail, or just to release you. And we have a video on bail if you have questions about that. And that's called a first appearance, where the court either releases you or sets a bail. And then within 3 court days, the court has to have a second appearance. And some courts do that in person and some don't. But basically, that's the deadline for the prosecuting attorney to file a written complaint to maintain those conditions on you, like bail or no contact, that got set at the first appearance. And so what happens wrong, Lance? Well, what happens is almost always the prosecutor does not rush file the case within the 3 court days, because there's just too many cases. There's limited resources. And so what you hear as the defendant is, the case is dismissed. Hey, they dismissed the case. All right, I'm out of trouble. Well, they didn't dismiss the case. By court rule, the probable cause finding had to be, and the restrictions on you had to be dismissed, but there never was a case filed on you. There never was a criminal complaint. And so people go about their lives thinking the case was dismissed and I'm out of trouble. And that is not the case, okay? Not the case. So If they don't rush file the charge within the 3 court days, then that criminal arrest and the police report goes to a prosecutor's office. In Snohomish County, it goes to the Snohomish County Prosecutor's Office in Everett. In King County, it either goes to Seattle or Kent. The King County Prosecutor's Office has a couple offices, right? In different counties, it goes to the prosecuting attorney for them to make a decision what to do. And so there's so much more to do. So if you've been arrested for a felony, uh, get yourself an attorney or at least contact one so they can try to help you through the process. There's things that can be done. Your story can be told. The total outcome can be changed by what you do now. The second mistake is leaving the defendant in jail after the first appearance, because that affects, in my opinion, the prosecutor's behavior. If your loved one's been arrested and they go to the first appearance and the court says, well, I'm going to set bail on you of $10,000. If you have the ability to bail that person out, again, a bonding company, you pay a fee. And we have a video on that you can watch. You pay a fee to post the bond. It might cost you $1,000 to get the defendant out of jail. But if you get the defendant out of jail, now it's less likely to be rush filed. Again, human behavior controls everything. If a prosecutor has a defendant in jail with conditions on them, and they're still sitting there, they're more likely to find a reason to rush file the case to keep that defendant in jail, especially in certain counties. So if you have an ability to bail the person out, you should do it typically. Call an attorney. I can't give you legal advice here, but typically speaking, it's an advantage to delay any possible charging if you can get the defendant out of jail. So if you know someone who's been arrested for a felony, or you are been arrested, you need legal help, please give us a call. Again, my name's Lance Fryrear. I'm in the law offices of Lance Fryrear. We've been defending people charged with crimes for more than 20 years. And if you just find this useful, please like the video, please subscribe. And if you need anything, give us a call. We'll do everything we can to help, and we'll be there for you. Thank you.